that enable and that help the Ethiopian political and other legal reforms that are currently underway. So these two rights are very important. When it comes to the legal framework in Ethiopia, the constitution also recognizes both rights under Article 26 and 29 of the same constitution. So there are also other enabling legislations that were enacted after this constitution. So these two rights are important when it comes to their interaction and the way these two rights interact. We can find, for example, the issue of communication surveillance. In communication surveillance, for example, human rights defenders, activists were targeted. As you all know, in 2014, the Human Rights Watch released a report entitled They Know Everything We Said. In this report, the Human Rights Watch highlighted that how the Ethiopian government was targeting activists and human rights defenders through taping and surveilling their daily activities. So these two rights are really important because these human rights defenders were targeted because of their dissent, because of their expression. The other area of their interaction is, the emerging right of, the right to be forgotten. Although we don't have a kind of detailed data protection law, unlike other countries, the right to be forgotten is another battleground for the right to privacy and freedom of expression to interact. And the other area is the issue of encryption and anonymity. This is also another area that these two rights could interact. So in the digital age, their importance is really vital, and it profoundly preoccupies many conversations in Ethiopia and beyond. Thank you.
Okay, thank you very much, Your Highness. So Pashis, can you tell us the landscape in your country?
Sorry, Sandra, could you repeat your question?
Can you tell us what the landscape is in your country?
What the landscape is in our sure. So I clearly didn't. I mean, my country that I come from is India, which is not part of this study. But I certainly, as I was reviewing a lot of the material that I was able to see here, I think a lot of very similar issues that come up. That there are certain. There's obviously a kind of freedom of expression that is enshrined in the Constitution that was clearly written into Article 19 of the Indian Constitution in 1950. The right to privacy, however, in India is a far more recent right. It was not explicitly mentioned in the Constitution. And in fact, for several decades, there was a lot of debate about whether there is a fundamental or any constitutional right to privacy under the Indian laws. And it was only in 2018, in response to the litigation challenging the digital ID system here, that we finally got a right to privacy in India, which was read into the right to liberty and other rights that are guaranteed in the Constitution. So in India, privacy is a recent right, and B, a derived right, because it is derived from other rights that are enshrined in the Constitution. To that extent, it is still unclear where the intersection of all of this sits, because we do not yet even, so while there is a fundamental right, the statute, which is the data protection law, has not yet been passed by Parliament. So how exactly these two rights intersect with each other in India is currently unknown, and that is something that we are kind of yet to see. In many of aspects where these rights do start getting intertwined, we are seeing a lot of kind of internet regulation or internet governance regulation coming out from the government, which do touch upon these aspects, but it is not yet clear where some of these will actually end up. So that's the when I see some of the findings from this research report, I do, as someone who's been in India and observing the trends here, see a lot of resonance with what others in other countries are finding. Thank you.
Okay, thank you very much. Favor, my next question will be directed at Favor. What are some of the threats to these rights in your country, and what does it mean for the civil and digital landscape in your country?
Can everyone hear me? can see me. I am always very worried about my network.
Yes, we can see it.
Okay, yes, thank you very much. My name is Favor Borokini, and I am a data and digital rights researcher with Policy. Policy is a Ugandan civic tech not-for-profit organization. And before I moved to Policy, I used to work at TechHive Advisory, and I had the opportunity to contribute to this report as well. So to your question, Sandra, about the threats to freedom of expression online and the protection of personal information in Nigeria, I would like to say that the major threats that the major threat is definitely has to do with regulation, government regulation, and well, the fact that regulation is definitely being used as a cordial, and it's definitely whenever we have these interactions online, there is sort of the fear that our interactions online, the ideas that we share and the communications that we make available amongst ourselves will bring down some sort of hostile regulation that will force people to change or modify the way they speak. So there's a threat of self-censorship as a result of regulation. And then on the other hand, there's also the fact that there's also inadequate regulation when it comes to the existence of these policies themselves, and also the fact that our judiciary system is very, very slow to respond to certain issues. And you can see some traces of bias in favor of whatever party or political ideology is in place. And then I also think that some of these threats are also motivated by the cultural biases and cultural tensions that already exist in the country. So when it comes to for instance, we've had conflicts in the past regarding blasphemy, and we've had certain people arrested for blaspheming over the internet. So in other places, in other countries, this would be, I suppose blasphemy would not really be much of an issue, but it is very much an important issue in Nigeria because we have all sorts of crises and conflicts between tribes and between religions. So these are some of the Nigeria-specific threats to freedom of expression online. And when it comes to protection of personal information, it's pretty much the same thing. I think there is currently a bill in process. I actually don't know what the progress is right now on the bill, but before the passing of this bill, before the advent of this bill, there used to be, and I think what we're working with at the moment is the NDPR. But there's also the fact that we criticize that because, well, like many other data protection regulations all over Africa, it's basically a copy and paste of the GDPR. So there's also the failing of context-specific regulation in that area, and the fact that it is also being used as a threat. There's this overhanging threat over the sharing of information. There's the fact that we are required to submit certain information, and the fact that we cannot exercise some of the rights that are made available under the existing regulation that we do have. Thank you.
All right, Samuel, I'm going to come to you quickly. My question is around, of all the 4 countries that we profiled, Botswana appears to probably have lesser impact or lesser, how do I put it, is it violation that I would call it. But can you please just walk us through Botswana's country-specific context before I follow up with another question with you?
Thank you very much, Ridwan. I am Senolo Mudise. I'm an associate at Botry Law Group. It's a corporate and commercial law firm. I specialize in technology and cyber law, and digital rights is one of the sub-areas of ICT law that I'm interested in. I wrote the country report for Botswana in relation to freedom of expression online and the protection of personal information. In Botswana, freedom of expression online is protected under the Constitution, under the fundamental guarantee that protects freedom of expression generally. So there isn't any specific provision or specific law that deals with freedom of expression online on its own. The protection would be found under the Constitution. Now, the Constitution itself, while it has this protection, just like any fundamental right, has its own derogation, which have to be given effect to. The right to freedom of expression may be derogated when it is reasonably required in the interests of defense, public safety, public order, public morality, or public health. It may also be derogated where it is reasonably required to protect the reputations, rights, and freedoms of other persons or the private lives of other persons concerned. I think here we could see that this derogation is the one that introduces or that gives effect to privacy in limiting the freedom of expression. It also may be derogated through imposing restrictions on public officers, employees of the local government, teachers, and the like, in as far as the information they may get in the course of their employment. These derogations are the derogations that would apply to freedom of expression online. There's also other laws which derogate this freedom, and that is the penal code. In our penal code, we have laws relating to alarming publications. At section 59 of our penal code, you will find a provision there which provides that any person who publishes any false statement, rumor, or report which is likely to cause fear or alarm to the public or disturb public peace is guilty of an offense. Now, speaking of publishing a statement, it shall be a defense to that charge of alarming publications if someone proves that before making such publication, they took steps to verify the accuracy of the statement, the rumor, or any information they may have disseminated. Also found in the penal code, we have a provision relating to insulting the president or any public officer, and it's at section 93. It provides that it provides that if the president or a member of the National Assembly or a public officer has been insulted, then one may be liable to prosecution for a criminal offense. Now, the violation of these provisions, particularly insulting the president, has mostly occurred offline. There hasn't been reports or a charge in relation to someone insulting the president online. Same applies to alarming publications. The provision that predominantly rises or comes about is one that is found in our Cybercrime and Computer-Related Crimes Act that relates to offensive electronic communication. That is found at section 18. Section 18 provides that any person who willfully, maliciously, or repeatedly uses electronic communication of an offensive nature to disturb or attempt to disturb the peace, quiet, or privacy of any person with no legitimate purpose may be found guilty or commits an offense and is liable to a fine not exceeding 20,000 dollars, which in dollar terms would be 1,798, or they may be liable to an imprisonment term not exceeding a year or both. Now, this provision relates to any person, but oftentimes you find the government, when when an individual or even the press have disseminated something in relation to the government, the person would be charged under this provision. And the question that always arises is whether the government qualifies to be any person. The questions arise as to whether the government's privacy could be violated such that someone may be charged for having said something bad about the government. This provision is currently the subject of a constitutional challenge. It has been brought before court. Someone who has been charged with this particular provision has taken the provision before court to say that its construction and its application is so wide that it tends to encroach unreasonably on the right to freedom of expression in general, although whatever they may have done was done online. We also have the Media Practitioners Act. The Media Practitioners Act requires that any person who is engaged in the business of publishing news registers, and this also applies to someone who may run a page on Facebook. It applies to someone who may run a blog. And from a human rights perspective, this has been viewed as being in contravention with the international standards of self-regulation by the media. The Media Practitioners Act requires that journalists and any other person who publishes be registered. And the question arises to say, if they have to be registered in terms of the legislation, what is there to be done if someone will not be accredited on the basis that the government may not want them to be accredited? In addition to that, during COVID, Botswana had COVID-19 regulations, which sought to deal with information disorder. Now, the criminalization of...
Stop you. Let me come back to you quickly.
Oh.
I'll come back to you quickly. All right, thanks.
Thank you.
All right, yeah. So, Sigi, I'm going to come back to you. I'm going to come to you now. And we're looking at the context in which we looked at it in the report was to see how the expressions of these rights online. So what has been the role of technology in both decline and also in amplifying whether the violation or supporting the expression of these rights? I say that because from the findings in the country, we found instances where people have expressed opinion online and somehow it's become an issue. So also, before we get into the issue of platforms, but maybe if you can also sort of address that shortly. Are platforms also, are they amplifying this, or are they also suppressing the expression of these rights? And I want you to do that quickly, because I really want everyone to have a bite on this particular question. Thank you.
Thank you, Ridwan. Is your question the role of tech or the role of social media platforms, or both?
Together. First is role of technology itself, then of course the gateways in which people also express some of these rights, especially freedom of expression, to be more specific, freedom of expression online. So yeah, if you can take it within that context.
Okay, so I think just as we look at the role of technology, I think it's important to recall some of the statements that have been made by, entities such as the United Nations Human Rights Council, who have actually called on states very explicitly and categorically to take into account the extent to which developments in information and communications technologies have not only changed communication practices around the world, but how this also impacts, the rights to one, to be able to express yourself freely, but two, to also be able to express yourself in a private manner. So I think simply summarized, technology is both a facilitator of human rights, including freedom of expression and the right to privacy, specifically anonymous expression. However, its manipulability is what I think has given rise to this perception that technology actually leads to the suppression of specific rights. And I know that that's a contentious statement, so I'm really hoping that people will engage with that statement later on. In terms of some of the gateways that technology has provided, as you mentioned, social media platforms are one of the gateways through which individuals are able to express themselves, either anonymously or in an anonymized manner online. I think we've also seen the rise of communications-based messaging applications such as WhatsApp, Telegram, Signal, amongst others, where a majority of us, at least those of us who are lucky and privileged enough to have access to the internet, are able to share information, to disseminate information, to share content, amongst others. I think that these platforms, and this will dive into the issue of intermediary liability, have a responsibility, and a lot of companies have come out quite categorically on the in recognizing the responsibilities that they have in terms of promoting both the right to anonymous expression, but also the right to the protection of personal information on online platforms. And we've seen this with Facebook's new content moderation board, which is increasingly issuing decisions, contesting and pushing back against some of the restrictions on the right to freedom of expression by Facebook itself. So Ridwan, I think I'll stop there. And I think my takeaway is that tech is both a facilitator, but manipulation has exposed both of these rights to restrictions and to suppression.
Thank you so much for that. Favor, I'm going to come to you quickly. In Nigeria, we've seen a trend where the government has been making legislative attempts to control things around speech, and now we have big conversation around information disorder. The government saying that its own solution to information disorder is by maybe criminalizing some speech and all that. If you look at that within the context of the question to Sigi, what would your opinion be? And if you can do that for me quickly as well, thanks.
Okay, thank you very much. Well, just like you said, in my opinion, technology provides both a platform for us to exercise our freedom of speech, to express communications, to share, to receive, to access ideas and all sorts of information, really. But technology itself, due to the fact that it is able to host these sorts of interactions, also makes it possible for them to be, for it to be threatened. So if we look at the fact that the threat to freedom of expression, for instance, comes from, well, if you're afraid that the government is going to, if the government says, as they have said in Nigeria, that for you to be able to buy a new SIM card, you need to register the SIM. You need to provide information about your name, your address, your next of kin, your location, all sorts of information about you. You need to thumbprint, and then the knowledge, I suppose, that the government has all this information about you, and the knowledge that that sort of power or access to that sort of information can be used to surveil whatever it is you are doing with the SIM card that gives you that very access, shows that technology by itself can be used to threaten and suppress the expression of freedom of speech. So when we think about also, I suppose, cybersecurity risks and privacy breaches and all these things, I feel that this sort of answers the question about how technology can cause a decline and can amplify these rights as well. Please, could you repeat the other question about the information disorder, please?
Yeah, I was trying to, different legislative attempts to say the Nigerian so far on information disorder, and trying to see how does this balances. Should the government take that strategy, or are there other things that the government should be looking at in terms of reining it in around addressing information disorder?
Well, I think that the Nigerian government is very worried about very interesting things. I'd like to quote a very popular journalist. He says that the Nigerian government it has a very interesting relationship with information or misinformation. So the Nigerian government does not care so much that certain things are wrong. What matters to it is that people are talking about these things publicly, or that global newspaper outlets are reporting information about this. So this misplacement of priorities, this misplaced priorities by itself ensures that the regulation that it spurs is not directly addressing what the issue is. If the problem really is that people are coming out to share misinformation, spread disinformation, malinformation, and cause commotion everywhere, then the government definitely should invest in digital literacy. They should teach the citizenry how to verify information. They should teach people how to report false information online. They should empower people to be able to seek out the truth for themselves. But we see that the reverse is the case. They don't want anybody to say anything they don't like, but you can say anything you don't like about whatever is not of interest to the government. So definitely the attempts, all these numerous attempts to pass laws that suppress information, libel, and all that is not coming from the right place, and therefore it cannot yield the desired results, really. Thank you.
You know, there's so much reports around how mandatory registration is a very big thing in so many parts of the world. And this is also being advanced by so many stakeholders in the telecom sector, and more importantly, on the side of the government, who believe by making it mandatory for people to register their SIM and capture biometric information, they are able to sort of rein in terms of national security. That's usually the argument. But we've also seen arguments or research that has actually demonstrated that sometimes these things really don't combat or sort of help in terms of solving crimes into that sense. So I'm going to ask you, and quickly, what's your opinion around things like a subject like mandatory SIM registration, which is something we've seen and is growing in so many parts of the world. I mean, for context, in Nigeria, it's not only just you're mandated to register your SIM. Now you also have to fuse your national identity number into that SIM registration process, which like two biometric database now being fused together. So what's your take on that?
Was that my question?
Yeah, that's what Subashi, sorry.
Oh, thank you.
Sorry, Ron, could you just repeat your question?
Yes, I was trying to like find, I mean, your thoughts around the issue of mandatory SIM registration, you know, for government is so much around national security and combating crime. And also the research have been also able to demonstrate that, man, this thing really don't help in solving crimes now, I mean, in that sense. So what's your take on that?
So here's how I would think about it, right? And I'll go back to my initial comments. These are all complex issues with no right or wrong, or what is right today might, given changes in technology, might no longer be right tomorrow, or vice versa. So I do not think we should look at answers to these questions at static points in time. But instead we should be asking, how are these institutions being set up to navigate these questions? So to your question specifically about mandatory SIM registration, right? And the justification being used about this helps in law enforcement and all of that, and national security. If you go back to the 3 principles of good institutions that I spoke about, and if you take the second one, which is around transparent adherence, then the question we should be asking is, can the government actually disclose that in how many cases of prosecution of some of these cases was evidence that was derived from these kind of systems used, and in how many of those cases was that clinching evidence? Then civil society, researchers, etc., can actually evaluate the data and validate the claims of the government to whether those things were right or wrong. In the absence of that kind of information being provided, it's all a debate in abstract. There is no evidence for us to actually have that kind of debate and discussion. So that, I think, definitely needs to happen, that some of this data needs to be put out, and civil society and media and everyone needs to have the opportunity to look at those. The second is, however, one might even forget the actual data, even at a principles level, that this might be something that is not acceptable, because it is a violation of both freedom of expression and in many ways individuals' privacy. So then the question arises that have due checks been passed before any of these kind of regulations have been brought in? So for example, if I'm mandating as a country that people link their digital ID and their mobile number, the question is, what is the legal and lawful basis for that? What is the act under which this was passed? Or is this just an executive order? If this is an executive order, is it deriving some kind of democratic legitimacy from some act of parliament or the legislature? So I think we need to ask these questions around legality, that is this really a legal order or not, or is this circumventing the democratic process just by some regulator coming in and bringing out an executive order with no public consultation, with no legislative checks, with no judicial checks? So I think that's one question. We should ask about legality. Secondly, we should ask about have the risks of these kind of moves been evaluated? Did someone do a cost benefit analysis from government and actually put it out before bringing this? So we need to really look at these nuts and bolts of regulatory governance before we do any of this. And in fact, I would refer to one of the there's a program called digitalid.design that the Center of Internet and Society has put together, and that actually provides a framework where you can ask these 13 or 15 questions each time something like this is done. So I think these are all complex questions, no right or wrong, but we need to ask about the context and the institutions within which these decisions are made.
Thank you very much, Subhashis, for that excellent response. This question is directed at Johannes. Considering happenings in Ethiopia, what do you think has been the costs and impact of network disruption?
Well, basically, internet shutdown has become, the hallmark of the Ethiopian government in the past 5-6 years. And even recently in the conflict in Tigray, in conflict areas, still the internet is closed, especially when the conflict is expanded to Amhara and Afar region, the neighboring regions. Still, in such places, internet and telecommunication services cut. So the problem is, we don't have any laws that discourage, internet shutdown. Of course, there are attempts by the Attorney General to have a provision under the Computer Crimes Proclamation, but still that law is draft, and the academic as well as the civil society opposes the move by the government because it will normalize the practice of internet shutdown, because internet is necessary in times like COVID as well as in any situation. So we advocate for open internet, open and unregulated internet. But the government is trying to have a provision under the Computer Crimes Proclamation. In terms of its cost, the cost of internet shutdown is profound. Even we have mapped the impact of internet shutdown in terms of human rights, for example, with one civil society called CARD. In a study, we found that this internet shutdown impacts almost every generation of rights, civil and political rights, socioeconomic rights, and also the right to development as well. In terms of even economy, one study found that internet shutdown costs Ethiopia $4.5 million per day. So that means if something happens for 1 month, 2 months, it's a lot. So I think the government now a little bit understands pushbacks from civil society and also academics. So nationally we don't have such internet shutdown. Even in the recent election, we don't have any shutdown. But in conflict areas, the one that is in the northern part, still there are some places. I am receiving some reports that internet is still closed, and even including telecommunication service as well. So the impact is profound, I would say. Thank you.
Favor, I don't know if you can share your thoughts on internet shutdown in Nigeria and recent events in the country, and how this impacts security.
Well, at the moment, we cannot currently access Twitter if you do not have a VPN. And this was last week when we had that Facebook and Instagram shutdown. I saw someone tweet something on Twitter, and she said that essentially Nigerians who do not have VPNs and who are not therefore on Twitter are cut off from the internet. And we need to think about the, like you mentioned, the security implications of that. If you are unable to communicate anything about where you are, if you're in any type of trouble, and call for help, call for assistance, then really I think that's just a very significant problem with internet shutdowns. And I remember last year during the what we refer to as the Lekki massacre in October last year, where till date the government still holds out that what happened there never happened, that soldiers never went to the toll gate to do anything. But we did see on Instagram, via Instagram live accounts by people who we heard the sound of gunshots, we had people crying, we saw wounds, we saw injuries. So the scope of what's of the harm that is caused by internet shutdown, I think that we should even not consider so much the cost financially, and begin to think about the impact on our health, on our psychology. We are social animals as humans. We need to be able to communicate and feel that there is someone there, there's someone out there who is listening, who understands what we are saying, what we're trying to pass across. And then there's also the lack of access to sexual and reproductive education for women, healthcare, financial education, sense of community essentially is lost. And these are some of the important costs that we need to count as regards network disruptions and internet shutdowns essentially as well. Thank you.
All right, Sigi, I know this is a topic you're very passionate about, to you, but before that, Dr. Patricia, I saw you raised your hand, and I'm giving you the permission to speak. If you can have your contribution quickly, thank you.
Sorry, I thought you oversaw me, so I decided to write it on the chat. Hello, you can hear me?
Yes.
Okay, I was my question or my comment was on a contribution by Subhashish. I hope I'm pronouncing the name correctly.
Yes, you are. Thank you, Patricia. So I'm able to see your question, which is, it's not necessarily just the structure of the instrument that is important. It's also kind of what is part of that instrument and where do you kind of come, where do you land on that? Patricia, I mean, the response that I would have to that is that these are, of course, highly subjective things, which my evaluation of what is valid and what is not might be different from yours. Of course, there are certain global norms, but at the end of the day, on rights-based issues, global norms only that useful. It is some of the national norms and laws that actually tend to kind of override that. So human rights standard in that sense will be fairly different from country to country. So while I think your point is absolutely valid and important, I also think it's one of those that one has to think, how do I do it in a way that is most kind of, it's not subjective and it's the most objective thing that can be done. And so the way to do it is, again, if I go back to the three principles that I spoke about, is to look at what is the kind of independent oversight and what is the transparency of that. So for example, when the law is being created, how is it being created? Is the law being created by a majoritarian government just bringing in the law and ramming it through parliament or presidency or whatever the structure of the government is, or has there actually been healthy debate? Was it put out for public consultation or not? So those are the markers of legitimacy that I would use. Can it be challenged in courts? Does the law have transparency that allows it to be challenged? What we do not want is a law that was brought in a hurry, that does not have any kind of transparency, so nobody can challenge it, and in many ways might even explicitly exclude the judiciary. So I think these kind of good practices in terms of institution building become important to get to the outcome that you're talking about. I worry that if we start with the outcome, then it sometimes becomes a little bit of an ideological debate that, hey, your principles and your values are different from my values, and therefore how do we arrive at a consensus? And I think we have to look at what is the democratic legitimacy under which these are brought. To just give you an example, when something like this in the context of India was brought in, the digital ID system was brought in through what is a particular kind of legislation that excludes a certain house of parliament. It was, while it was eventually upheld, but the dissenting judge called it a fraud on the constitution. So I guess what we have to ensure is that we have fewer frauds on our constitution, and that for all of our countries, we are really doing this in a way that upholds the spirit of democracy rather than just the structure of democracy.
All right. Thank you, Subhashis. Thank you, Dr. Patricia, too. I mean, I think those are like really valid questions around surveillance laws. And also what's problematic is for so many African countries, the fact that even the power to conduct surveillance is even not situated in just a single law. You have it scattered in different laws. And it's really difficult to know what laws the law enforcement agencies are relying on, or even if they are complying with the provisions of the law. So I think it would be good if these laws could actually enjoy the benefit of being tested in the courts, and we'll see where we go from there. Thank you very much again. Sigi, I'm going to come to you now. I want your opinion on the impact of network disruption. How does it impact, I mean, I say this at the fundamental level, how does it impact the ordinary people who are just trying to access the internet? For a whole lot of people, Facebook is just their only gateway to the internet. What does this mean for them when they're taken off grid completely?
Thank you, Edwan, and apologies. As I mentioned, I am balancing between my phone and my laptop. So internet disruptions. I think we must fundamentally, as previous speakers have stated, internet disruptions have become so prevalent across the region that they have now become what is defined as an established norm. And that is very disappointing because governments are putting out these commitments that they want to expand connectivity, but then issuing these contradictory messaging by shutting down and disrupting the internet. In terms of the individual impact of internet shutdowns, I think we must look at it not just from a rights perspective, but also, as you mentioned, from a livelihood perspective. A large majority of individuals these days have transitioned their businesses online. A large majority of individuals, and here I say a large majority because in my head I have this perception that we are all connected, well, at least in a utopian world, which is not true. A certain percentage of individuals, to correct myself, use online and digital platforms to be able to make money. Simply put. And so these disruptions, not just looking at it from a cost perspective, disrupts people's livelihoods, which essentially means that you are telling people to go without food, to go without shelter, to struggle with their financial obligations on the ground, without then providing them with any sort of safety nets or any sufficient justification at the very least to describe and illustrate why it is that you are preventing them from being able to exercise their right to work online. So I think from that particular perspective, significant restrictions are being imposed and placed on individuals without proper, as Subhashish mentioned, without any cost benefit analysis being conducted, without any human rights impact assessments being conducted. And this is particularly problematic. I think also as we look at it from the perspective of individuals being able to access the internet, the internet essentially has become a lifeline for societies, to keep, and as well as businesses as well, not just looking at it from the individual perspective, but also looking at how businesses themselves are consequently impacted, as well as government providers, because, for example, in Kenya, a lot of services have transitioned online. And so if an internet disruption was to take place, the government is essentially telling individuals that they are halting services to do with access to identification cards, that you will no longer have access to be able to obtain or renew your driving license. And so the repercussions are not just from a cost perspective. I think it's also important for us to also look at the unseen costs of internet disruptions, the kind of messaging, the kind of negative messaging that it sends to individuals who rely on these platforms to be able to, as you mentioned, to be able to live out in the conceptions of the good life, to be able to access and sell their goods and their products online. But for me, I think, the unseen cost that we usually forget to look at is the perception, the negative perception that internet disruptions, send across societies, that the internet is not a human right, when many jurisdictions, for example, Indian courts have come out and stated that the internet is a human right, amongst others. So Ridwan, I think that addresses the question of, what are the individual cost, individual repercussions of shutdowns at the individual level. And it's unfortunate that some of these costs, despite entities such as Access now coming out and stating, relying on economic arguments to be able to push back against internet disruptions, these just don't seem to be sufficient. So the question is, what will governments listen to? What do we need to tell governments for them to be able to lessen and reduce the number of disruptions that they effect across the internet and across connectivity platforms? Thank you, everyone.
Thank you very much, Tigi. Samuel, I'm going to come to you right now, and I know this is a subject you're very passionate about. That's on the topic of encryption. So we found, especially in like the Nigerian chapter, for example, where you find express provisions of law requiring the communication service provider to install capability to be able to decrypt the encrypted communication. And when we have laws like this that are geared at weakening encryption and also to take encryption away, what does this really mean for us in terms of how important encryption means for what encryption means to preservation of freedom of expression and also a protection of our personal information? And more specifically, I want you to address why even in some of these countries that enables the decryption capability of law enforcement authorities, why it's even not subject to even a judicial review or maybe an independent oversight body.
Thank you very much for the question, Ridwan. We cannot undermine encryption's importance in amplifying the right to freedom of expression as well as the protection of personal information. Really, with encryption, people know and are able to communicate safely, freely, and express themselves in a manner that does not interfere with their rights. But with the government having access to decryption, then it really reduces the strength of the right to freedom of expression without justification. In every constitution, there would be derogations for not enforcing fully fundamental rights. And those derogations need to be justified. But oftentimes you'd find that the justification for national security, the justification for public safety is overemphasized, but without the relevant research. So many countries that have decryption keys cannot prove that decryption ultimately translates to the reduction of crime one way or another. Actually, it is used strategically by government on occasions that are inconsistent to be able to get access to information. But in my view, most of the time it is unjustified, and there's many ways through which information can be gotten access to without necessarily weakening the system inherently. I'm not sure if I got the last end of your question. If you could repeat it so that I could address it.
What I was saying was, I think you've actually addressed the questions sufficiently. Being able to talk about the role of encryption and all of that. What I was saying was that what does this mean when even the power to do these things are not subject to a judicial oversight or even the role of an independent oversight body? And I know sometimes, contrary to international principles on communication surveillance too, you also see the fact that even people who are subject to these things are not even notified about their existence.
Yes, that is so. You would even find that in a country like ours, to have access to someone else's information by the intelligence agency takes an ex parte application where the party concerned does not have the opportunity to oppose or to bring forth why the information should not be accessed. So most of the time it is arbitrarily applied and there is no checks and balances to ensure that human rights are safeguarded. So you may find that, yes, the government may say to us that they are giving us access to technology and they are committed to the fourth industrial revolution. But on the other hand, they use this opportunity, they use the access to gain access to people's lives, to violate freedom of expression as well as the rights to privacy without the necessary checks and balances. So it may be helpful to push the topic around checks and balances for governments, because across board, even with internet shutdowns, even with issues such as this decryption, there usually isn't any checks and balances, and those would not be provided for under any law, so that we may be sure that in applying these derogations, they are actually justified in a democratic society.
Sandra, you're muted.
So this question will be directed at Johannes again. What are your thoughts on intermediary liability? Should we start rethinking intermediary liability? What do you think?
Thank you, Sandra. This is an important question. When it comes to intermediary liability, for example, the Ethiopian government is trying to enact a provision under the hate speech and disinformation suppression and prevention proclamation. In that law, it mandates social media platforms, to take down illegal content, including fake news or hate speech within 24 hours upon receiving notification. So this is one step that the government tries to regulate internet intermediaries. And other than this, there is no such detailed rules. But recently, following the war in the northern Ethiopia, the government is, complaining about illegal and partisan removal of, contents that are said to be pro-government and, contents that are said to be pan-Ethiopian. And the head of the Information Network Security Agency accused Facebook that it is fueling conflict and supporting, the separatists by pulling down contents that are said to be pro-government. So what the head of the Information Network Security Agency suggested was we will, develop our own laws, as well as we will have our own alternative social media platforms. Maybe that could be inspired by the Belt and Road Initiative, so that we could, decide on our cyberspace, what the head said. Having said that, if we see the policy and other interventions as well, the media policy in the country also highlighted that the government is willing, to regulate, intermediary liabilities. Of course, the prevailing understanding of, intermediary liability at the moment is a little bit marketized, and, let the platforms themselves regulate. And this needs to be, questioned as well, because we need to have a sort of structural understanding of, regulation, and governments in a way protect, the rights in the digital space as well. So my suggestion is, like, maybe, in a democratic process that is, supported with due process and human rights based approach, states in a way develop some sort of regulating the behavior of these Leviathan, these platforms, so that, we do have some sort of regulation. Otherwise, if we go this way, the platforms sometimes use their discretionary power, as well as, they at times arrogate unbridled control over user-generated content, and also they can pull down any content they host. So this will be problematic. I hope the African Commission on Human and People's Rights also. Yes.
Thank you, Johannes. I want to direct the same question to other panelists. So Milo, what are your thoughts? Should we rethink intermediary liability? And do you think that we need more of government regulation or self-regulation? What are your thoughts?
Sometimes maybe I could jump in.
Okay, Siki. All right.
So, the way And I like the approach that Subhashish had taken in terms of looking at things. We have seen several countries, including, I believe it was the Mauritian government, coming out and stating that self-regulation by intermediaries is not effective because they're not able to deal in a rapid manner with issues surrounding national security and public order, as loosely and vaguely defined as that may be, whereas intermediaries themselves maintain that government regulation leads to overly stringent requirements, which in some instances may not be practically applicable. So because during my tenure at Article 19, we supported the former African Commission Special Rapporteur on Freedom of Expression and Access to Information. I think that the position that he had set out in that particular document is a position that we should continue to adopt. And the position is this, that states so the first thing is that states should not require internet intermediaries to proactively monitor content, which either they have not authored or modified. So here the insistence is on limited intermediary regulation, only in very certain specific situations. So for example, the declaration states, for example, that the removal of online content by internet intermediaries should be prohibited unless certain grounds are met. So one, the request should be clear and unambiguous. There should be judicial oversight or other due process safeguards. There should be compatibility with international human rights laws and standards. There must be transparency, which is often where we see a lot of non-state actors pushing back, because some of these content removal requirements to internet intermediaries are so vague and so hidden and so non-transparent that it then lends to the perception that government regulation should not be permitted. One of the other requirements that had been put out in the declaration, and this speaks to the issue of the use of, for example, algorithms or automated technologies by internet intermediaries, is that these should be compatible with international human rights law and standards, right? Building upon the obligations that private entities specifically have in terms of their responsibility to respect human rights as set out in various guiding UN documents, to make sure that they do not consequently infringe on the rights to expression, to information, as well as others. So, just to conflate the issue, should we go the government regulation route? Should we go the self-regulation route? I think this also speaks to the issue that we're seeing in terms of the content moderation arena. And I think one of the solutions that has been proposed by organizations such as Article 19 is to create what they're calling these social media councils that essentially bring together. So here you'd be bringing together government, you'd be bringing together the internet intermediaries themselves, and then you'd be bringing entities that are able to check and provide oversight over the implementation of some of the decisions that these mechanisms make. How practical that is a different question, but I think just in terms of just creating and constructing solutions to some of these problems, I think going that council route, that local council route, might be a viable solution, but it is expensive. And it is time consuming and it is demanding. But I think with some of these issues, because they are pertinent issues that speak to the protection of people's rights, it is important for us to be able to put in time, money, and investments to find adequate solutions to their resolve. Thank you, Sandra.
You're welcome. You're welcome, Sigi. Thank you for your response. What do you think? Should we go to government regulation or regulation?
Thank you very much. I think first we must recognize that platforms have given effect to the right to freedom of expression in ways that would have never happened had they not been there. We should also recognize that these are businesses, and with strict intermediary regulation from government, then it may put them out of business. Just like in the media, self-regulation may strike a balance between the freedom of expression and the right to privacy, because usually the concern is always that with a blank check on freedom of expression, people tend to impact negatively the other individuals' right to privacy. But if we are to introduce the government totally regulating the space. It may be that they may not give effect to the interests, the commercial interests of the platforms, and that may discourage platforms to keep developing and to keep having these platforms that give effect to freedom of expression. So in my view, we could start with self-regulation, but moving towards co-regulation like Sigi had hinted. Thank you.
Thank you very much, Sumelu. Favor, can you share your thoughts on whether we need more of government regulation or self-regulation?
Okay, thank you so much, Sandra. So, well, I think this might come as a surprise, but I do think that we need more government regulation. I don't agree very much with the idea that self-regulation is enough for for platform regulation. And I know that this conflicts a lot with the idea that by many of the internet founding fathers that the internet should be sort of a space free from outside interference, government interference. But when we look at the state of rights, ironically, such as the right of freedom of expression and right to dignity, you see that there are no rights that are absolute. For instance, my right to freedom of speech stops when it begins to infringe on, I suppose, your right to dignity, for instance, or I am not permitted to defame a person only just because I have the right to freedom of speech. So, but without, I feel, government oversight, that is ideally, then we see that all sorts of minority rights begin to get encroached upon. So then the internet becomes an unsafe place for ethnic minorities, sexual minorities, women, elderly people, and all that. So I think that ideally, what we really need is an approach whereby the internet is appropriately regulated through policies and legislations that are developed based on public interest, by reflecting a sort of regulation and policy that reflects the needs and values of the people that will be subject to them, not government regulation that seeks to impose ideas of digital sovereignty or surveillance and all that. So in my opinion, I don't think self-regulation is enough. I don't think it provides appropriate protection for the people who would need it the most in online spaces. But at the same time, I recognize that government regulation as it is today is not sufficient. It's not what we need to ensure proper exchange of ideas on the internet and in online spaces. Thank you.
Thank you very much, Favor. Sorry, I think you're raising your hand about, I'll come to you pretty much later. I know we're running out of time, and I this really is not exhaustive. The time is never enough to exhaust this quality of conversation. So before we take maybe one or two observations from people who were able to join today, I'd just like to have some sort of a concluding thought from everyone on the panel. If we can do that quickly, maybe about if we can do that in about 90 seconds. So Bashir is able to join us back, join again, and I would like to hear from him, especially in his own capacity. And now that recommendations have been made to different stakeholders, which include organizations like ISU, what direction should we be looking moving forward? And every other panelist will take turns in also sharing their final thoughts. But we need to do that. Okay. Thank you.
Thank you, Ridwan. So my kind of concluding thoughts on all of this, in fact, it has been informed a lot by the research that you and the group have done, is to say that what I think we need at this point is focus on two things. I think we focus a lot on whether a law is right or wrong. We focus a lot on our own evaluation of those laws and how those are playing out. I think we need an equally strong focus on the way by which that law has been created. What are the checks and balances inherent in the law? So we have to look at, I think we have to look at laws not just as what their content is, but you have to look at laws by what their structure is, how much transparency, etc. are they creating. I think these challenges we are facing are only going to become more and more complex. I think especially, for example, in the encrypted messaging platform space, there's a conversation on or there have been moves towards traceability in India, they've been there in Brazil, and I think it is a matter of time before it reverberates across the globe. So there's going to be a lot of pressure on these hitherto safe spaces where people thought they had a lot of privacy and freedom of expression. There's going to be legislative moves which are going to risk eroding it. And as we start grappling with these deeper and tougher questions of our times and that technology is throwing up at us, I think what becomes really important is to make sure that our democratic institutions themselves are strong enough and equipped enough to be able to deal with these. I agree with Favor that self-regulation itself might not really work on a whole bunch of these issues. And I think what we really need, therefore, is it will have to be in some way regulated or moderated wherever regulation is required by the government. But at the same time, what are the checks and balances that we are putting in place to make sure that the governments are accountable, that they're transparent, that these are specific laws for specific problems, that there is less delegation and there's less discretion to government officials to do what they want. So I think these are all the complex questions of our times that we'll have to grapple with, and obviously all of us have to be fairly engaged in this kind of a conversation. So those, Ridwan, are my concluding thoughts.
Thank you very much, Subhashish. Sawelo, the final thoughts.
Thank you very much. I agree with Subhashish, but I'd also like to add that I think governments should be alive to the times in which we are living in, the rapid developments in technology, and try as much as possible to keep up with them, to try as much as possible to join in the conversation so that the laws are able to effectively protect the individuals. There is nothing as said as a law that is passed but is unable to be effective. So I think the governments should be alive to things that are currently happening, and they should find a way in relation to technology to pass law which are alive to the challenges that keep being brought up day in and day out. Otherwise, we'll always be talking about conversations after technology has developed 10 years ahead of us. Thank you.
Sigi?
Thank you, Ridwan. I don't want to repeat a lot of the fantastic points that have been made by the previous speakers. I think what I want to focus on is the issue of implementation of laws. So, we've looked at the problems with the legislative drafting of particular laws, but I think we also then need to be focusing on the implementation of some of these laws, as Dr. Patricia had flagged out in her post. That sometimes the legal framework itself is problematic, and yes, we do take these legislative frameworks and regulatory frameworks to court. So also bearing in mind the important role that the courts play in terms of reasserting people's rights both online and offline. But I think we also need to pay a lot of keen attention to the implementation of how these laws are being implemented, because individuals are being impacted by the implementation of these laws. And being impacted in a very negative manner. So, we're capturing some data on how, for example, online content regulation laws have impacted individuals' abilities to freely express themselves. And it's not just about restricting rights, it's also about the kind of repression and fear that you instill into people's minds. And I think that is something that we really need to pay attention to and to be able to push back against. Ridwan didn't really touch on the issue of the journalistic exemption provisions, because I think that this is really where the right to freedom of expression and data protection intersect quite beautifully. One of the things that, or rather one of my last takeaways is for individuals, as data protection laws are being passed and implemented in your countries, please push for the insertion of journalistic exemption provisions into your data protection acts. because without this particular exemption, the ability to be able to report on public interest matters then becomes constricted under the guise of the protection of personal information. So yeah, Ridwan, I think that those are my final takeaway points. Thank you.
Thank you very much for raising the issue of journalistic exception. I personally have shared the same opinion with you, and those are some of the things I've also found very problematic with the existing data protection law we have in Nigeria, and also the draft law that excludes journalistic exception. Ioannis?
Thank you, Redon. Actually, previous speakers also highlighted, and I want to emphasize that on the need to have a kind of holistic intervention for all these problems, especially regarding authoritarian practices. We need to mount pressures on governments, for example, on the issue of internet shutdown. We organize and we just pressure the government not to enact laws that normalize internet shutdown in Ethiopia, for example, is an instance. And other than that, regarding the unbridled power of platforms, we need to have a kind of holistic interventions such as co-regulation. Maybe sometimes if the government also enact laws, that should be in a democratic process and that respects international human rights law. So there is no a silver bullet for this problem, but we need to be holistic enough to regulate both the behavior of states as well as the social media platforms as well. Thank you.
Thanks, Ioannis. Favor.
Okay, thank you, everyone. So from our discussions today and from everything that I've read in the reports, I think that I'd like to round up by saying that to me, the relationship between freedom of expression online and the protection of personal information relates to a broader conflict between, I suppose, conflicts between existing human rights. There is a need for a bigger discussion about how the various human rights that accrue to us as human beings, as citizens, sometimes conflict or contradict with each other. And I think that we need to discuss this more, discuss how a person's right to freedom of expression contradicts or conflicts with the right to privacy, for instance, or the right to dignity. So I believe that if we are able to bear more on this, on the balance that is needed in order for us to be able to exercise each and every one of these rights, then we'll be able to contribute to better, more fruitful conversations and make online spaces safer for everyone. Thank you.
All right. Thank you, Favor. I was wondering if there's anyone any attendee who probably want to share their thought. Or in the absence of that, I really want to thank everyone for attending. Thank the panelists. Thank you, Subhashish and Omidyar Network, for supporting the project. Thank you to everyone who contributed to the report too for being phenomenal along the line. And it's a long road. It was a long road, but at the end we're able to make sure we put this out, which of course we also consider to be a very significant contribution to the conversation on the continent. Thank you very much. Thank you very much, everyone. Again, I'm really grateful. I appreciate a lot. Tech Hub Advisory says thank you, and we hope to do some other interesting collaborations in the future. Thank you, everyone.
Thank you.
Thank you.
Thank you, Subhashish. Thank you, everyone. Bye.
Thank you.